Our first speaker to kickstart the afternoon session is Mr. William Heath from the UK. Mr. Heath is an entrepreneur and a Young Foundation Fellow. May I invite Mr. Heath to the podium, please?
Thank you very much. Thank you for joining me for the after-lunch session, and I hope you can hear me at the back there. Very happy 20th anniversary to Hong Kong for achieving its righteous status, and very happy birthday to the People's Republic. 68th birthday this weekend. I'm sorry we'll miss the fireworks. The one time that I visited Beijing was when the Young Foundation was invited by the then Prime Minister's favorite think tank to discuss how we could help the PRC establish a thriving NGO, a thriving third sector as part of the harmonious society. So the night before we flew out to Beijing, we were all invited to dinner by the British Council to wish us good luck. But they had a warning for us. They said to us, while in China, do not criticize China. We said, of course we wouldn't criticize China. We're guests. We're very excited. China's a fascinating and wonderful place. They said, yeah, but there's one more thing. While in China, do not criticize Britain either. We said, that's going to be a real problem. I don't know how we're going to do that. Anyway, we flew out. We had a conference for 2 days. We heard from some fascinating, dedicated South American, Indian, social entrepreneurs doing incredible things for no money, and also from Chinese deputy mayors shouting at us about their city's extraordinary growth and environmental performance. And after 2 days, I'd made quite good friends with the deputy head of the think tank, and I explained our problem to him. I said, we are trying to share with you how to have a vibrant NGO sector, but we've been told not to criticize Britain. Why do you think people do these things? People are drawn to the brokenness in society. People in NGOs are insanely critical of their governments all the time, but we've been told not to tell you that. The secret is you have to find a way to protect this ecology of dissent. And my host thought very, very carefully, and then he said, in modern China, it's okay to be critical as long as you do it in a constructive way. I think it's very good advice. So please accept what follows as a provocation and not a prescription. On my trip out, I've been reading the Chinese Taoist, Chuang Tzu. I'd like to propose that the international conference adopts him as their key teacher, because he's very funny and very wise, and he has some really spot-on messages for this topic today. Chuang Tzu teaches us to deconstruct the language that we use. He says that the Tao can be talked about is not the true Tao. And the words that we use in this session this afternoon, privacy, consumer, data subject, consent, and notice, these are not the way. They're simply not adequate to construct a human foundation of trust in global online relationships. Now, you all know the basics of this better than anyone in the world, but let's restate as a start point. Notice. There's just too many notices, hundreds of them for each of us. The notices are too long, typically twice as long as my talk to you today. They're too complicated. They cover every eventuality for the company and leave the individual naked. Each service, however trivial and commonplace, has to have its own notice. Now, it's fine for the other side's lawyer to talk to my lawyer. It's not okay for me routinely to sign whatever someone else's lawyer sticks in front of me or my child. It's fine for my machine to deal with someone else's machine. It's not okay for me to spend my valuable human time engaging in dialogue with machines that can't engage, adjust, or respond meaningfully. The notice is presented in an instant when I want to get something done, but the consequences last forever. Relied on as a universal cure-all, notice is less of a panacea and more of a laughing stock. So this is Giles Pilbrow in the UK satirical magazine Private Eye. There we are. I think that is more concise and more truthful than any notice and consent you'll ever meet. Now, next problem word, consent. If the notice is inadequate, and it is, as we've seen, then the consent is pretty meaningless. It's not limited, I've got no choice, it would take valuable time to think about it, and it's not negotiable anyway. Meant to fix everything and used everywhere, it becomes devalued, like antibiotics applied universally. And the result of this is that what should be healthy online relationships are instead built on devalued and degraded contracts, which undermine trust and mutual respect. Now, you could imagine ideal consent, or at least adequate consent, and Europe's GDPR makes a serious effort at that, requiring consent to be specific, granular, clear, prominent, opt-in, properly documented, and easily withdrawn. And beyond those good GDPR criteria, it would be great if consent was as standardized as possible, issued by my machine to your machine, actionable so that there are remedies in the event of breach. But fully implementing just the basic GDPR requirements presents challenges, technical, legal, and commercial. And I should explain, for our hardworking translators at the back, when we say presents challenges, that's British English for it's completely impossible, forget it. Consent that takes any real effort is only worth seeking for the limited occasions where there's a really significant decision, where the decision and the considered consent actually matter. So can we start, as a point for our discussion today, can we reject the notion that we gave adequate consent to what is now being done with our personal data? It seems very odd to rely so heavily on consent when it's completely obvious that it's human nature. We all make bad decisions all the time. This is a cartoon from Zach Weinersmith. I think he nails this issue. The customer is being sold an Alexa or some sort of snooping device. He says, absolutely no way. The salesman says, but it can figure out when you're low on cheese balls and drone deliver them in 30 minutes. Give me the machine, he says. These bad decisions won't stop. And a legal construct that fails to recognize the bad decisions won't stop will not put us on the right path. So from a data contract point of view, we've got the information age off to a bad start. The words are stuck, but the reality is changing very fast, and of course, that's about to get much worse. The amount of data we generate is increasing faster than Moore's law. As we sign up to ever more services, we enter ever more agreements, barely any of which ever get read. And now we add a more order of magnitude increase to the acceleration as not just complex devices like cars and mobile phones, but also things that should be completely straightforward, like toasters and light bulbs and fish tanks, are sold as internet-connected devices wrapped up with terms and conditions or a manufacturer's privacy policy. By now, we do everything digitally. We work, we socialize, we learn, create, share culture, and relax. It's a large percentage of our human lives, all of it observed and increasingly manipulated on this flimsy legal basis. Yes, we buy goods and services, but we're not merely consumers. We're producers and agents and creators and friends and family and much more besides. And yes, there's data about us, but that doesn't reduce us to being data subjects. Subjects are acted upon, patronized, infantilized. Subjects have very little meaningful agency or control. Data subject is a legal term devised for a specific purpose, but the term belittles us as humans in an information age. Our international conference teacher, Chuang Tzu, teaches that we don't have words for things that we haven't experienced. And we haven't experienced what really happens to our data. Now, of course, regulators have to put up with their fair share of ridicule. Griselda, who drew this cartoon for Private Eye, by the way, she sends very best wishes for a successful conference to all of us. In her picture, the regulator's getting cold-shouldered. For now. I'd like to see her draw another cartoon where the regulator has just issued a 4% of turnover fine to the executives in that picture. But there is a change of gear now. Notice and consent was born out of well-intentioned US consumer protection principles. But in drafting the GDPR and the other parallel legal developments that we've heard about this morning, the Europeans see a fundamental right at stake, the right to privacy, constitutionally protected in several countries like Germany and also now India. GDPR may offer superior protection, but I would suggest it still can't make consent entirely fit for purpose. Even in doing what it does, which is still not enough to please the consent purists, but it's already far more than the corporate lobby wanted, it may make consent unviable as the lawful basis for a whole swathe of activities such as insurance. PCV, cartoon, we'll have to find a different way of going around this regulation. So that may push businesses to use one of the other half-dozen lawful bases for the processing of data, which is still within your remit, but beyond the scope of our session here. I found this diagram by Marty Abrams, who's with us, I think, very telling. It suggests regulators are making some progress at regulating the data that individuals provide, but very little progress in regulating observed data, such as CCTV, and no progress to speak of in the valuable and fast-growing areas of derived and inferred data. So regulators are still at step one, and it may feel like this problem is getting away from us. Contracts based on lying that you've read them are broken. Marketing is broken, certainly if the basis is meant to be consent. Given the chance, given the legal right, an overwhelming majority will choose to end that relationship. This brokenness perverts the business model of the media that we depend on to reward creators and keep society well informed. The New York Times CEO recently described digital advertising as a nightmarish joke, a total mess, out of control, and a dangerous environment for brands, his customers. He then added, there's also a negative side. Digital marketing isn't just annoying and increasingly creepy. It's based on data of very dubious quality. As businesses and governments use the same data for risk management, turning to the same discredited data brokers to manage fraud or make recruitment decisions, these vital processes also become tainted. We're like flood victims trying to survive in a toxic soup of leaked personal details. Detailed profiles of us are now in the hands not just of companies and governments, but also of hackers and crooks based on these shabby data contracts. It's unprecedented. The head of Britain's MI6 spoke in this context of profound risks, a fundamental threat to our sovereignty. And we've seen extremely serious consequences. Malevolent actors have tilted our public discourse to strike a mortal blow against the EU and to put a delinquent narcissist in the White House. It's as bad as the widespread delinquency that preceded the fall of Jerusalem 2,500 years ago. The prophet Jeremiah warned the Jews in really stark terms of the wrongness of their ways at the time. These same words could ring out in the boardrooms of Equifax and other data businesses operating behind our backs. Be appalled, O heavens. Be shocked. Be utterly desolate. These people have committed two evils. They've forsaken me, they forsake the individual, the fountain of living water, and they've dug out cisterns for themselves, cracked cisterns that can hold no water. No one paid any attention to Jeremiah. What came next was Old Testament fire and brimstone on a truly biblical scale, followed by a major rethink on ethics. So this toxic soup, the fetid water leaking from the cracked cisterns, is our problem here today in this room. Perhaps very few of us will shed a tear if Equifax and others go the way of Lehman Brothers and Enron. But we have to try and fix the wider problem before our world collapses. And it feels like all we have are these broken words and fatuous checkboxes where the wording is the wrong way around and you have to read it twice. There's a wonderful German word, Weltauffassung. It evokes how we grasp or understand the world, drawing on every discipline available to us: science, philosophy, culture, faith. It feels like our Weltauffassung has broken down. We're left crying out like the hero of a mid-19th century German tragedy, "Ich verstehe die Welt nicht mehr." I do not understand the world anymore. Or in Taoist terms, it feels like we've lost the way. But perhaps that's not surprising. We're in the process of connecting the entire world in all its diversity of nation, culture, and worldview. That is an insanely ambitious and optimistic undertaking. Technology has made a certain connection. Ethics, law, and regulation need to catch up. If we're to have a frame of reference for how we understand and regulate global life online, how we codify these relationships and keep ourselves and our societies healthy, that will need a deep and broad worldview. That's the scale of the question that lies behind the apparently intractable problem in this session. I'm not sure we can solve it today, but we have to raise it here, now. Given not just your responsibilities and professional skills, but also the wide diversity of cultures, backgrounds, principles, and beliefs represented here. This concerns not just the artificial constructs put together by government and business. It's not just arm wrestling between free market advocates and the regulator. Our patron teacher, Chuang Tzu, shows a profound hatred of anything that seeks to enslave or control the human spirit. You can just imagine the sort of cryptic postmodernist anecdotes with which he would have ridiculed the governments that came up with the Aadhaar card, the surveillance state, the citizen score, or an open market in our browser history. In a similar vein, the psychologist Josh Cohen gives a great explanation of why privacy matters in his book, Privacy: Why We Live Our Lives in the Dark. He argues whether you look at the human condition through science, religion, or his own discipline, which is psychology, you have a set of known externalities, the body of scientific knowledge, the sacred texts or buildings, or the problematic behavior of the client that brings it to the therapist. But in each case, Cohen says, the part that matters is the part we do not know and cannot put into words. The undiscovered knowledge or scientific questions, the inexpressible divine in religion, or for Freudians, the id, the part of the mind that is unknowable both to the therapist and also to the patient themselves. So to try routinely to intrude on people's private lives and to codify that essence, this is the meat and drink of surveillance capitalism and the surveillance state. This goes, Cohen suggests, right against the grain of human nature, however we understand that, through whichever discipline, and also it's doomed to failure. So the issue at stake isn't limited to our fundamental right to privacy any more than it is to consumer protection. The way that we need to follow will lead to the richness and complexity of global connected individuals and organizations, treating each other with dignity, growing trust, and friendship. And that's why these words, consumer, data subject, notice, and consent, are too limiting. They're valid in a way, but they're soulless. They're devoid of anything that people actually care about. Clearly, whatever basis we end up with for our global data protection governance will have substantial US, European, Chinese, Indian, and other elements. And it'll reflect free market aspects and government concern for security and well-intentioned bureaucratic interventions to try to protect Enlightenment principles. We may find some shared and common values, but inevitably we'll find a lot that is distinctive, different, and incompatible. Connecting with different cultures of the world awakens us to the full range of the human personality. This is a wonderful thing. It's also terrifying, of course, but it's wonderful. So my own journey to here is as an entrepreneur. My first business researched the computerization of public services. I was completely shocked to find that this was done with no effort at all to base it on the needs of the individual. After I sold that business, I co-founded several other businesses, anticipating an inevitable shift in control to the individual, some working on cooperative principles. One of those businesses is Control Shift, which is a successful research and advisory company. It does the annual review of the called Personal Information Economy, which reviews what I'm about to talk about next. Control Shift finds that big businesses now seriously want to understand what happens when customers take charge and how the commercial and compliance implications of that play out. I have to say that regulatory pressure has been a clear and direct contributor to the demand for these sorts of services, so thank you. Understanding that shift towards personal control and agency is one thing. Actually doing it, actually offering individuals not just lip service, but meaningful control over the data and relationship will take somewhat longer. But there are, to my knowledge now, a few hundred entrepreneurs of this sort with a range of increasingly serious offerings, some represented with us today. It's a tough undertaking, but entrepreneurs are resilient, and we believe that this sector, personal information management systems, personal data stores, personally controlled identity, and trust frameworks that connect governments and individuals and businesses, will eventually be transformative and the rewards considerable. So my hypothesis, to start your discussions this afternoon, is that we've made a fundamental error. In the way we've codified these online relationships, we've inhibited the growth of the human spirit and excluded the individual. I mean, what can individuals do today? They can withdraw, they can opt out, they can try to unravel who holds what data and where they got it from, but it's a hopeless task. One woman, a student at the Royal College of Art, got so fed up with the privileged status of corporations as people and their encroachment on our lives that she incorporated herself. JLM Inc. now transacts with the rest of the world as a corporation. She explores aspects of quantified self and personal data, and she might even get some tax breaks. I think if her project is a success, perhaps we should all follow suit. But what we need is to empower individuals so they can get stuff done, regain control, responsibility, and agency. I don't want some fancy bear configuring my social bubble of fake news. I want to configure my own bubble. I want to control and use my own digital credentials, the proofs of the valid relationships I have, my own track record, my customer data, so that I can assert claims and manage and share my own preferences. The crucial next step in this is the introduction of the individual as a node in a person-centric data architecture, instead of data simply being shared between organizations in a continuing organization-centric mindset, which has resulted in the toxic soup. Without underestimating the challenges of culture change or human and structural inertia, I and other entrepreneurs are confident that market solutions based on an individual-centric model and privacy-friendly services are set to have a transformative effect on our online relationships, on trust, and the information economy. I believe they'll be more convenient for the individual. They'll offer more valuable trusted relationships to business with richer data on a permissioned basis, and help governments focus public safety efforts where they're most needed. I'm trying, after my reading on the plane, to see this through Chinese eyes. If we empower individuals and give them agency and control, there will be a very tiny delinquent fraction of a percent who would abuse that and require authoritarian legalism, close surveillance and control. There'll be a decent percentage who will respond to REN, the firm but compassionate Confucian guidance. But I think the vast majority will respond very well to the Changsu Taoist approach. They will find their own way with unpredictable but wonderful consequences. Including the individual and letting individuals use their personal data to accumulate trust and evidence supports personal development, and better information logistics. That helps everyone. And there's a key regulatory role in this. Now that holding personal data is going to start costing real money, businesses are going to want either a solid return or to cut their costs by transferring that responsibility to the individual. Everything else in the world has gone self-service. The same will happen to personal data management. And it's not just a cost and a regulatory saving for business. There's a sales upside. The most economically valuable data is not in the toxic soup. It's not in the fetid pool. It's decisions which are yet to come, future buying intentions. That's the sweet water. I don't know if Isabelle Falk-Pierrotin is with us, but perhaps under her stewardship, next year's conference could look at the question of personal data as an appellation d'origine contrôlée. Because I think the French wine industry has shown us very clearly that a race to the top of quality is far better than a race to the bottom, a sort of lake of vinegary wine. And that's why I believe that GDPR means growth. So, we're in the wrong place. Regulators are being asked to perform an impossible task with inadequate resources. But we can get out of this mess, and your role is key. The great thing is, you do not have to deliver a perfect regulatory solution. A strong, dense regulatory thicket is enough to force up the cost of bad practices, to expose bad actors, and to help us find our digital Tao, the way of nature, with the emergence of new market solutions. So I hope in your discussions this afternoon, the conference sees that as an eminently feasible and incredibly worthwhile challenge. I'm very happy to meet up with anyone afterwards, take questions, or offer links back to any of the references that I've made. Many, many thanks for your invitation and for your attention this afternoon.
So we are supposed to start at 2:15, but now it's 2:45. And I have been informed that we still have 1 hour for this session. So that means we are going to finish at 3:45. For this session on notice and consent, we have 2 speakers, and their biodata is in the program. I would like to call upon the speakers to the stage, and we can start the discussion. Yeah. Thank you very much. And as I said, this is a parallel session on notice and consent. We have heard William Heath in his speech giving us the problems with the notice, problems with the consent, and what could be the solutions to these problems. And my duty is just to facilitate the discussions. I'm Munir from Faculty of Law, University of Malaysia. So I have 2 minutes to just to start the ball rolling. As we know that in Asia Pacific countries, we have the law in Singapore, in Hong Kong, in Malaysia, in Japan, and in Korea. The law is very clear. Before you can process data, you have to provide notice and get the consent of the data subject. The practical question that we need to ask now is that whether or not that notice and consent requirement, or as required by the law, is working. And if it's not working, what to replace that? do we have the solution, or do we have the alternative or options to this consent and notice requirement? Basically, the underlying principle is consent. Before we collect data, we have to get the consent. Before we disclose data to a third party, we have to have the consent. Again, as I said, whether this is practical enough, whether it is working in the real situation. And I've been requested by the organizer to look at this issue not from, if possible, not from companies' perspective, not from regulators' perspective, but to look at it from ordinary people on the street, whether or not this consent and notice requirement works. What I'm going to do in this session is that to have some preliminary thoughts from our speakers, then we go ahead with the discussion. So I would like to invite Professor Hongzhu to give some preliminary thoughts on this issue, perhaps 10 minutes.
Well, thank you very much, Professor. I'm from Beijing. I noticed the title of this session is actually the notice consent from India to Japan. There's nothing to do with China. That's interesting. China is geographically in between these two countries, so probably I give very brief introduction. The Chinese law on consent, on data protection. Well, in the morning, we've learned from the very insightful presentation from Professor Wang from Beijing. He talked about that China has a new general stipulation of civil code. And in that very important legal initiative, privacy is finally a civil right in Chinese legal system. China is a civil law country, so it's very important to have this statutory legal basis. But he didn't mention whether we have a separate civil rights on personal data protection or personal information protection. Because we don't have a comprehensive law on data protection so far. Well, that's something like an American approach. We have many regulations based on industrial sectors, based on topics, based on the different authorities. So this, for data protection, so far in Chinese legal system is kind of like a legal jungles. You have to go through, navigate in this matrix, where to find the legal sources to support your claim on data protection. The most relevant legal basis so far is pretty clear, a very recent one, and it's just entered into Chinese legal system. It's Chinese very well-known cybersecurity law. And in the morning and over the lunch, I heard a lot of discussion on this new law. And so probably I can use this new law to provide you my very initial learning about consent. Because consent is a very complicated issue in this new law. And I can talk about, I'm not going to limit my presentation on the principle of consent. Of course, that's pretty clear. Under the cybersecurity law, because this is only law, is made by National People's Congress, is either our national level is much higher than the regulatory issued, for example, by the Ministry of Industry and Information Technology, MIIT. This is the law, not a regulation. In this law, the number one principle is that whenever you want to collect, process, or transfer the other people's personal information, you must get the consent. Actually, it's informed and the expressed consent is pretty clear and high-level protection. But the devil is really in details. I want to give you 3 examples to show that in the following circumstances, consent either is irrelevant or is impossible or is actually exempted. The first example, consent is being exempted. I mean, consent is not required. Under the law, you cannot transfer the other people's personal information without a prior informed consent, except the following circumstances. If this personal information has been irreversibly anonymized, it can be transferred. Oh, what's the point of this? You're all experts. What is the legal meaning of this irreversible anonymization? Oh, well, okay. Let's go back to Professor Wang's point. That's because China is very keen in developing the big data industry. Now there's many big data exchange centers have been established in China. This is very serious industrial 4.0 initiative. Because you don't have to acquire consent, and you can analyze, process, and even transfer these so-called data products. Well, through this big data technology. Of course, it's very cost-effective. But this is very much a backdoor to personal data protection. Well, in the morning, we learned that the data profiling is a big issue, actually, for personal data protection. In China, this is not even an issue because it's legally exempted from consent. So this is circumstance 1. 2, mission impossible. There's something, the law requires the industry to acquire consent from the data subjects, but it's not possible. That is, I use the example of IoT, Internet of Things. Internet of Things is another very big area, especially for China as an emerging economy. We have many head start on Internet of Things. Under the cybersecurity law, the law actually requires that if you have a product with a function of collecting people's personal information, you should get a consent. Oh, this is very good legal design. We say privacy by design. I fully agree with that. The issue is how to enforce and implement that. How to get people consent to the Internet of Things. Think about, we don't even have the minimum transparency of these products and this operation. Probably is tap pings randomly and send the information back to the data center. How do we know that? We consent, probably we have a general consent when we purchase the products. We have no control of that. It's totally beyond our control. And that's kind of an implied consent, a passive consent. Well, that's really not a consent. Or the third example and third circumstances is not mission impossible as Internet of Things, is actually irrelevant. You consent or you not consent, it will always be processed. That is the cross-border data flow. This is another interesting legal design in the cybersecurity law. Under this law, there's a special legal requirements. So anybody who is running a critical information infrastructure, we call CII, you must store all the important data and the personal data in the territory of China. If you want to transfer the data overseas, you must get the special evaluation. But the measure on this evaluation is still being drafted. So now this is general requirements. Now we heard a lot of comments from the overseas companies puzzled. What will be evaluation and what is the meaning of important data? Well, I'm more interested in this personal data. For this personal data, it means that you agree or you not agree is irrelevant. This is legal requirement. This must be stored within China. Your data center must be established in China. And you agree to be flow out of the territory, that's not implementable. So this is 3 circumstances I used to explain how puzzling the consent could be in reality and in practices. Since I only have 10 minutes, so I stop here and leave to you for any comments, questions.
Thank you very much, Professor Hong. Now I'd like to invite Ms. Naoko Mizuko Koshi to give initial thought on this issue.
Thank you, Professor Munier. My name is Naoko Mizukoshi. I'm a lawyer working in Japan. I'm happy to share the practices in Japan about privacy. As introduced in the morning sessions, we have the Personal Information Protection Act, which comprehensively applies to private sector. That was firstly enacted in 2003 and amended in 2015. And the amended act fully came into force this May, so it's quite recent development. And regarding the notice and consent rules, we had them in the 2003 Act already and have maintained them in the amended Act. So we have been doing this practice over a decade. The notice and the consent rules require either obtaining consent for the use purpose during the contract or transaction processes directly from individuals, or notifying such purposes by privacy policy, so on. With regard to the enforcement, if someone uses personal information beyond that scope of consent, the data subject may initiate a lawsuit and pursue damages against such person in a court, claiming that personal right is infringed based on the tort theory. Privacy right is included in personal right as one component in Japan. There is a court case that a person who used medical record for the employment management purpose rather than the treatment purpose of the liability for compensation of damages, since such use was out of scope of that consented purpose. So here, I'd like to touch upon two features of the amended act related to notice and consent. So one is that we newly adopted the stricter consent rules for the sensitive personal information, such as race, creed, medical history, or criminal records, so on, which would cause unfair discrimination, prejudice, or other disadvantages to individuals. The previous act did not have the rules based on the nature of personal information, but individuals should have greater control and take much more careful consideration over this sensitive information. So this is progress by the amendment. And secondly, the amended act introduced a notion of anonymously processed information to respond to demand for big data analysis by businesses. So this is regulated by law, and guidelines give guidance for anonymously processed information in Japan. I think the new rule gives businesses incentives to handle personal information anonymously rather than use information which identify individuals. That is also beneficial for individuals from the protection of privacy perspective. So during the amendment process, I see the good practice in Japan. So Personal Information Protection Commission, PPC, communicated and heard voices of both businesses and citizens. The multi-stakeholder process was not included in the amended act itself, but we repeatedly discussed the value of multi-stakeholder process during the amendment process. Hence, PPC made efforts to learn what's happening in the technology and business aspects and citizens' concerns, and then tried to balance the promotion of innovation and the protection of privacy before finalizing the amended act and associated rules. Reflecting such learning process during this period, PPC has issued guidelines and FAQs, and I think that is quite helpful for both citizens and businesses. So I think we should continue the multi-stakeholder approach to solve any difficulties which may arise from notice and consent or other regulatory requirements or other issues. When I think about Japanese culture and environment, Japan has the advanced ICT infrastructure, including network, and smartphones and other ICT devices are widely accepted in the society. This is advantage for consumer as well. Then, if the choices are very limited and just yes or no options to privacy policy, users may decide not to use services. Actually, I see such phenomenon in Japan from time to time. This may be a cultural thing. And that may not what service providers hope. and users may not be able to receive the benefit of technology advancement. Or businesses may broaden the scope of usage purposes just in case users have to agree on such broad or big usage purpose. That is another issue. I think that notice and consent model should be supplemented by the requirements for the transparency of service providers' use of personal information, the efforts on explanation of service providers' use of personal information, and the efforts to provide a wide variety of choices. Actually, we see that some trends when businesses have updated privacy policies to accommodate to the amended Act. But the level of effort still quite varies depending on businesses. So PPC, academia, and professionals are required to play roles sharing best practice among businesses and users and pointing out in the cases of lack of transparency or efforts for understandable explanation or providing choices. Then, of course, the enforcement against the fraudulent conduct is very important. So I look forward to discussing with you. Thank you.
Thank you very much. Now, I would like to invite questions, views, comments about this issue from the floor. Whether or not notice and consent requirements as required by the law in Asia-Pacific countries and under the GDPR, as we know, consent requirement has been strengthened, and whether this consent and notice requirement really works, especially in the area of big data, in IoT. In big data, for example, yes, you collect data for a specific purpose, then you want to use it for other purposes in relation to big data. The question now is that you need to come back to get the consent for the data to be used for other purposes. So it is a practical problem, and I would like to open the discussion to the floor. Comments, views. Yes, go ahead. Can you just mention your name?
Hi, my name is Alex. I'm from Price International, a charity based in London. I had a question for the first speaker from the Institute for Internet Policy and Law. You mentioned different examples of exemption or where consent was impossible or say relevant, and so I was just wondering, what are the alternatives then that you're exploring? Because I think that's only the beginning of the conversation to realize that consent may not be the only way forward, but I think we need to start talking about it then. What are the alternatives? Because at the end of the day, consent is one of the fundamental data protection principles. If that's not the avenue we can take forward, then what is? And that maybe other speakers have comments on that.
You would like to respond to that, Professor Hung? Yeah, you can use that microphone, please.
Oh, thank you. I fully agree with you. The three examples I've used shows that consent, even though it is a fundamental principle, is a lot of defects in practices. Yes, we need to find alternative solutions. One possible solution, or my colleagues mentioned the supplementary solutions, maybe to enhance transparency. That's quite important, especially for the Internet of Things. So far, we don't know how these products are running and how are they collecting and transmitting and processing our data. That's something that's really concerning me, at least. So but before consent, we need to understand what is happening. So the transparency is definitely something we need to improve and insist. And another thing for the big data, we noticed both China and Japan introduced exemption, the legal exemption for enable the big data analysis. That's because it's too costly. If we use the GDPR, the European model, it will be very costly for big data industry. Just imagine they will have to come back to the data subjects to acquire consent. That's why we introduced this legal exemption. But we can see in these two jurisdictions the different legal approaches. For Japan, you have a process, right? And how to assess or evaluate the data, the personal data, has been really anonymized. And in China, I guess that process is still missing. And I guess our lady mentioned we need kind of a multi-stakeholder involvement or governance process. If the people would be able to participate in this big data anonymization process, we would know whether this is safe or not, whether my personal data is really not identifiable anymore. I think that's an alternative solution, but there's very much depends on the legal design and practical practices. Yes. Right.
Any other comment or views? Yeah, coming back to the issue of big data, it seems that the law in China and Japan provide for exemptions. How about other jurisdictions? Or do you have any other comments on this issue? Yeah, please.
Hi, Stephen Gardner, Bloomberg BNA. This is a follow-up to the last question, really, to Professor Zhu. You said that the GDPR is much tighter on consent and the use of data for big data and anonymization. But is the consequence of that a greater trust in the processes in Europe compared to in China? It's very hard to have any trust in what's going on when it's impossible to know really what's going on and if data really is being anonymized and not really identified and so on and so forth. So where do you think a balance might be found between trust and the flexibility to use data in this way?
Anyone would like to comment on that, or perhaps Professor Hong? The argument is that, yes, GDPR requires, GDPR has enhanced the consent requirements, specifically mentioning it has to be informed consent, it has to be unambiguous consent. So his question is that by having enhanced consent basically can lead to a greater trust. Anyone would like to comment on that? Is that really acceptable? Enhanced consent leads to a greater trust? Yeah. From the audience, please. Or do we have any questions? You know, I saw someone raising the hands just now. Yes, at the back, please.
Helen Wallace from GeneWatch UK. I agree with the concerns about trust if you don't have consent from individuals. And I just wanted to raise the issue of medical information and health information, including genetic information. And there are, additional requirements. For example, the ethical principles from the World Medical Association. In Europe, there are also consent requirements in the Clinical Trials Directive, in the new In Vitro Diagnostics Directive, that would require consent for data that's collected for the regulators in order to predict health conditions, for example, with medical software. Now, that's a very important part of big data. Do the people on the panel also think that maybe consent isn't necessary for medical data, or are you saying the exemptions should be much narrower than that?
Medical data. Yeah, any of you, guys.
Thank you. Currently, medical data is very strictly handled in Japan and with very much careful consideration. And this is based on the consent, of course. And so I touched upon the Amendment Act and sensitive information issues. And when we talk about personal data, the types of data is quite varied. and from like medical record and just name and addresses or businesses, telephone number, etc. And so I think such sensitive information protection is very important, and consent is cornerstone of the protection. And on the other hand, effective use of such useful information for the next generation treatment, medical treatment, is another issue. And so the industry is carefully thinking how to anonymize or protecting information and use such information for the next generation treatment. Thank you.
Can I have a
Any
follow-up?
other comment? Questions? Yes, please.
So, sorry, I just wanted to, maybe I wasn't clear when I spoke
Right.
before, but I was hoping to get a
Yes,
response
please.
from the panelists on this issue of trust and if data processing and the anonymization exemption in China can be trusted.
Yeah, okay, this is a good question. This very critical question. When we talk about trust, normally we mention the consumer trust in the market. When we put it in the perspective of international trade, this issue has become very serious. And it's become kind of a legal barriers. If there's no trust between two trade partner countries, and cross-border data flow will be disabled. And that will be very fatal to digital economy. Well, just imagine Chinese companies also have serious concern over the implementation, the upcoming implementation of GDPR. The Alibaba or Tencent, they are operating in Europe. They worry about the European law enforcement against them. And of course, those international giants worry about the implementation of Chinese cybersecurity law. So these are the trust issue between the trade partner countries is really a big problem for the global digital economy. So let's go back to the, let's use the original expression in the European Data Directive. They said that the comparable data protection. And now it seems GDPR is raising that level. It's more than comparable. It must be equivalent, a reasonable level of protection. Let's see, do we have the international consensus on that? If we have no consensus on that, we have a different standards, criteria, implementation, then of course no trust, and there's no data flow. And for this big data, there's even more serious problem. It means that, for example, for the Chinese very big internet companies, they're all developing very big cloud computing services. Alibaba is the world's second cloud computing service provider, just behind Amazon. They have data center around the world. And because of this mistrust or no trust between EU and China, I guess they are not going to continue or effectively running their data business in Europe anymore. Of course, they can use the big data exemption under Chinese cybersecurity law. That's very much legally permitted under Chinese law, but that's not existing in European law. There's no comparable legal design in that jurisdiction. So they cannot provide that service because there's no legal basis. And I want to have a response to the lady's question about sensitive data. And the Chinese law, there's no legal distinction between ordinary personal data and sensitive data. But when we put the different laws together, China have many other laws. For example, have tort liability law. In that law, we mention the medical privacy. So it seems that if this is medical data, it should be within the scope of medical privacy. And in that case, it shouldn't be subject to any big data analysis because that's within the very clear legal protection of privacy rights. This is another layer of legal protection, perhaps.
Let me give another example to show that consent and notice and consent requirement has got some problems. Normally, you give notice together with the privacy policies of your company. And research have shown that not many people basically read your privacy policy. And do we have the solution for that? I mean, you know, people do not read privacy policy for whatever reasons, and they just tick the box, allowing consent. I mean, allowing you to process the data. So in that sense, notice is not effective because it's not read by the data subject or the customers. So any comment on that? Or any views or any suggestions? I mean, especially if you have pages and pages of privacy policy, because I know in Malaysia there is a bank, I've read the privacy policy, basically allowing them to use the data, and if you look at the list, A, B, C, D, E, F until Z. So what's the purpose? Basically, you know, allowing the banks to use the data for whatever purposes listed from A to Z. So in that sense, it defeats the purpose. Yes.
Peggy Eisenhower from the US. And I would like to have the panelists and you comment in that vein on the remarks that we heard from the speaker before. And the context I would bring is that I don't understand why we as professionals expect individuals to bear the responsibility for evaluating the processing activities. I came from the US, I came from Atlanta, Georgia. I was on planes for approximately 24 hours to get here.
Okay.
The airline did not ask me when I boarded to consent to the safety measures, but I trusted completely, you know, do we need notice and consent for trust? I trusted completely that I would arrive safely. Doesn't mean that planes don't sometimes crash, but I trust that it's very safe. And I agreed with the previous speaker that these concepts of notice and consent are broken. Why is it my responsibility to determine if big data is appropriate from a privacy perspective or safe? Why is it my responsibility to determine whether IoT is safe? There's a lot of data processing. The innovation is very important. But why doesn't that happen in a way, in a regulatory community, in a self-regulatory or co-regulatory market that assures my trust because of those controls, rather than putting the onus on me to understand the big data or the IoT controls? I don't think that's appropriate. So I would like to have you guys comment on the disconnect between the legal regimes in Asia today and the, I think, very provocative message that we heard an hour ago, that these mechanisms really don't make any sense.
Anyone from the floor would like to comment on that? Yes.
Sorry, Alex from Price International again. There's, reflecting on what was just said, and also the challenges around getting consent, especially when it comes to data analytics and big data, and the imposition and burden that would be on the private sector. I'm confused at what point in the conversation we've started to sideline fundamental protection mechanisms that have been put in place, that have been decided and agreed by regional and international mechanisms to protect the rights of individuals and users, have been sidelined in the name of profits for companies. The big data and big data analytics industry is a $16 billion industry. I am sure that some of that can be refunded to think about alternative ways to ensure that the right to privacy and data protection of users is protected. So in terms, again, to my question of alternatives, I think we need to be considering some of those options as well, because it's not an option just to sideline consent and sideline user rights.
Yes, please. Clarice?
Thank you. Clarice Giraud, Asian Business Law Institute in Singapore. I think this discussion ties in nicely with the notion of legitimate interests in GDPR and the fact that Singapore, for instance, considers implementing the notion of legitimate interests in its Personal Data Protection Act later this year. Is that a concept that appears in Chinese or Japanese law at all, knowing that legitimate interests in the meaning of GDPR, is understood as a balance of interests and rights? So the second part is very important. Does that mean anything in Chinese and Japanese law?
Can I have comment from Hong Su and Noriko?
Oh, right.
The concept of legitimate interest.
These are all very insightful comments. Well, let me put it this way. As I said at the beginning, China has no comprehensive law on data protection. At the current status quo, legally, we don't have, for a citizen of China, we have no independent civil rights on data protection. Actually, the law provides the protection the other way. So it is not, let me put it this way, unlike the EU model, the data subjects cannot claim its rights. Instead, the data controller or processor has some legal obligation to protect the data. So this is the Chinese model. Of course, the consent is very important to protect the legitimate interest of the data subjects. Under such a legal design, the consent, at least seemingly a data autonomy for the data subjects. I'm asking you for your consent. This is in your control. But this is kind of a metaphysical question. In reality, you don't understand the contents. This is very long, very complicated. The lawyer's language, not even human language. You don't understand. You just blindly click through, I agree. This is not a real consent. At lunch, we talk about either the false consent or forced consent. This is not so much genuine consent. But at least this is true. It is in your control. You can consent or not consent. You agree or disagree. But I want to go back to the point is that we designed this cornerstone of consent in data protection law. For whose benefit is this legal institution? Is this a legal excuse for the industry to get the consent to process our data? Or this is really a legal protection for citizens, preventing the misuse of data? I guess this is two different things. So far, I guess, because the consent is not very much true, it's not genuine consent, this is very much for the industry to get the excuse. Okay, I got a consent. I can process the data and even transfer the data, produce the data subjects, produce the data products. I heard from our very big company, Alibaba, that they claim very clearly a proprietary rights over the data products. That's very much based on big data analysis, and it's based on analysis of our data.
That sounds interesting, claiming the rights over data by Alibaba. Perhaps Ms. Noriko, you'd like to comment on that?
Yeah.
The concept of legitimate interest, yeah?
And others. So I'd like to make two comments. So in Japan, we do not have clear legal concept of legitimate interest in the law itself. But as I mentioned, based on multi-stakeholder process or other schemes, industries explain the benefits for, let's say, medical record or other things. And so the society is trying to accommodate to balance the interest and benefits, I think. And so in the second point is, I think current consent, notice and consent model may not work, but explaining how to use the information is very important and the cornerstone still. And individuals would like to check what businesses notified to individuals in the future later on. So that's important. But at the same time, in Japan, we try to, in the smartphone and the telecom industries area, we try to make dashboards to inform users how to use personal information in mobile applications. And so, as I said, notice and consent is still plays still important roles, but we need supplemental tools such as dashboard or more easily understandable tools for users, and interaction between businesses and users, how the technology would deliver the benefit by anonymously processed information, etc.
Thank you. Yes.
Good afternoon. My name is Sharon Frank. I have a question. I came to this forum because my company really struggles with the notion of consent. The reason is, I'm just going to give a very concrete example, is that we treat people with kidney failure or no kidneys.
Okay.
So basically these people have to go to a hospital 3 times a week. So we have a product business, but we have a service business. So we basically, what we sell is treatment. And the doctors and the nurses, they work for us. They are our employees. So then you give a patient a 4-page document, very technical and detailed. These are
Right.
old people. How do you deal with the fact that when these people don't sign for consent, right, no other legal basis, we will treat these people because they will die if we don't treat them. And there's no other clinic in the area, in remote areas. So I think, one point I wanted to make is that there's like a lot of focus about what should be in the notice. I think the focus should be on how do you communicate this to vulnerable groups. And I would like to hear your thoughts around a situation where you are dealing with sensitive personal data, because this is medical data that we are processing, but we can't get consent. People don't want to sign for one reason or another. Maybe they're illiterate, they can't read, they're above 75. How do you as a company deal with that? I think we are trying to do the right thing because we will continue to treat these people. But from a legal point of view, I just want to hear your thoughts around that, including maybe also, I'm going to add the consent for transfer as well. How do we deal with that?
Right. Anyone would like to respond to that question? Not necessarily from the panel. As I said at the outset of this session, we have to look at it from ordinary people perspective, not from corporates perhaps, not from the experts, but I mean, she gave a very real example, the difficulty in getting consent in a very specific circumstance to get the patients or the customer to provide the consent for his or her medical record to be processed. Any comment?
So
Yes, go ahead, sorry.
Yeah. So we have in Japan, we have an expectation under the circumstances of urgency and welfare, for welfare. So it depends on the situation, but the exception might be applied. But it depends on the situation, and doctors and other workers at hospital are working too hard to make the final decision if they can do that treatment without consent or with consent. But the law allows for such urgent situation.
You would like to comment, Professor?
Right, for this medical services, medical data. That's very sensitive, I must say. And I guess it's very important to get consent from the patients. And the Chinese law is very clear. If there's no consent and you provide the treatment, the doctor or the medical institution will be subject to very severe legal liability. So they've desperate to get the consent from the patient or from the family member of the patient. That's a measure for exemption of the legal liability. This is very understandable practices. But the issue is what you say, how to make the informed consent to the patients in China, because there's very severe disputes between the doctors and the patients. Sometimes it triggers some violent incidents. So normally the doctor will have a meeting with the patients and the family. They will explain what is the consequence, what is the process, right, to improve the transparency, to disclose all the information involved, try to get a informed consent, a real consent.
So much focus on China and Japan. Perhaps any comment on the position in other part of Asia on this issue of notice and consent? Singapore, even Hong Kong, perhaps? Are you happy with that requirement, or are you facing any difficulty, basically, in enforcing the law with regards to this issue? Or any questions on comment? And the next issue is that whether or not we can rely on technology to replace this consent. Empowering the customers or empowering the people or the data subject and allowing them to manage their own data. Any idea on that? No comment? Are you happy with the legal requirements so far? Yeah.
Good afternoon. I'm Ken Young from Macau. So I would like to just follow up a little bit regarding the questions about the difficulties of in obtaining consent from the data subjects. And from the regulator's point of view, consent is always important because it's the control of the individuals themselves on their personal data. But in reality, we do understand that sometimes it's very difficult to get the consent, and sometimes even the industry is very good to provide a very detailed explanation on their purpose. It's on the data subject side that for ordinary people, it's very difficult to understand what the data controller is saying about. So they just simply choose according to their own preference, whether they trust the company or not. If they trust the company, they will just take. If they don't trust the company, they just close it. But regarding the legitimate interest, I think that there's always room in our DPA, in our Data Protection Act or some other data protection regimes, that if the data controller have some kind of recognized legitimate interest, and then they can proceed the data processing. In our practice, sometimes it's the regulator's responsibility to check on that, or sometimes we can authorize the change of purpose even if there's no consent from the data subject. So regarding some projects of cooperation between Macau company or Macau government and Alibaba, and I believe that they still need to ask for our authorization on that regarding the change of purpose. I totally agree with Professor Abu that sometimes we just ask them whether you can use some kind of technology to about some technology of the identification, so that the data is no more personal data, and then you can use it for research purpose, some other purpose. But there's always some risk of re-identification, and that's also our concern. And sometimes as a regulator, we do understand the needs in business and the needs from the public agency. We want to issue some authorization of the change of purpose without the consent of the data subject. However, the data controllers themselves sometimes fail to prove to us that they have a legitimate interest, or they have provided adequate measures, technical measures to protect the data. Just follow up some conversation before regarding the airplanes flight safety. I think if the companies or if the data controllers can prove that they have legitimate interest and they have adopted enough technical measures to protect personal data, I personally believe that there must be always some way out to process the data without the consent of the data subject and with adequate protection to the data subjects. That's my opinion.
Thank you very much. Any questions? Any more questions or comments? Yes. Yeah. Yes. Then you.
I think, well, okay.
Yeah.
I'll take it first. Thank you. About anonymized data, we're not talking about notice and consent, but exceptions too, so it's still a valid point, right? Are there cases where you know that anonymization actually works and has been recognized as a valid solution for an exception to consent? I worked for the French regulator for 15 years, and I know by experience that it's very hard to be sure that anonymized data will remain anonymized over time. It can be anonymized, today, and then in 1 year time, it won't be anonymized anymore because there are more data sets available, because technology evolves, etc.
Right.
So are there concrete cases in either China or Japan where you would know that, anonymization has been used as a valid exception to consent? It's a horrible question. I'm sorry.
You would like to comment, Professor Hong? Anonymization?
Well, our cybersecurity law is very new. It's just being implemented from July this year, so there's only 2 months. I don't have a very concrete example to show whether it's working or not. But for me, based on my very limited technical knowledge, the anonymized data, legally they should be irreversible. But technologically, I don't believe that's possible. For digital technology, it's always possible to be de-anonymized, right? So that's always some risk in practices. And how to legally guarantee it won't be de-anonymized. We need a process, as I mentioned. We are developing that missing link. Right?
And to some circumstances, anonymized data is not valuable as personal data, depending on the purpose. So what is important is that, you are able to identify individuals rather than, anonymized data. So in limited circumstances, as I said, personal data is still needed. You would like to comment, Erica?
Yeah. In Japan, the amended act is also new. That came into force as of May. But of course, the law prohibited the identification. And so it, in my opinion, that relates to data governance by businesses. So as you said, technology and more data enables businesses to identify. But the company may have strong data governance policy inside the company and separate the data set carefully and incorporate the rules internally. Or other company may combine by mistake or intentionally, and that leads to uncareful the identification. So it began recently, and as you pointed out, we acknowledge that technological point of view, it is possible to identify, but how to deal with this regulation which prohibit the identification, and businesses understand the importance of data governance. Thank you.
Okay, can I have last questions?
Yeah, it wasn't so much a question as a comment. We talked a lot about trust, and when we're talking about, we kept saying company in singular, but actually it's companies, because what we're seeing, especially in data analytics, is not just one company, but multiple companies sharing data, transferring data. And so in terms of the data lifecycle, that's just an additional challenge. If the alternative consent is going to be transparency and trust, it can't just be with the first company that's collecting or generating the data, but it has to be at every moment of the data lifecycle, which might be the same problem then as getting consent at every moment of the data lifecycle. So that was just a final comment.
Thank you so much. That's the end of our session, and I would like you to join me to say thank you to the panelists. Thank you so much.
The last leg of our session on notice and consent will be a panel discussion. This session will bring together all the ideas raised during the last 4 breakout sessions. To lead our panel discussion, we have 2 co-chairs, Mr. Jacob Constam, former chairman of the Dutch Data Protection Authority, and co-chairing the session at the far end is at the other end is Mr. Malcolm Crompton, Managing Director of Information Integrity Solutions. May I invite you to come onto the podium, please? And joining the 2 co-chairs, Professor Abu Bakar Munir, Professor of Law at the University of Malaya, Malaysia. Ms. Pam Dixon, Executive Director of World Privacy Forum. Mr. Jose Alejandro Bermudez, Managing Director of Nimity's Latin American business. And Ms. Malavika Jayaram, Executive Director of Digital Asia Hub. I will now hand over to the moderators for the panel discussion.
Thank you very much. Good afternoon, everybody. My first observation or plan, together with Malcolm, is to let you go at 5 o'clock so that you can have a drink somewhere. That's a good start of this discussion, but there's also something wrong. The title is Getting It All Together, and will not be getting all together after the beginning of remarks of the keynote speaker, who in fact said to all of us that sort of notice and consent, I would say, is done with. It isn't helpful. We need to search for other solutions if we want to get data protection and privacy strong enough in this new era. So there's 4 sessions that have been taken place somewhere in this building, and there's 4 moderators who will report, and I would urge them, if possible, not to be complete, to give everything that was said during the session, but to see what solutions, what other possibilities are there, except for the notice and consent sort of strategy. So, Malcolm, if that's all right with you?
Yes.
Who has the best solution? You did. Go ahead. What was your session? What was the title of your session, and what was the outcome?
Thank you very much, Mr. Chairman. Yeah, our session was on notice and choice. We had a very lively discussion on this issue. The feeling is that consent is still needed. That is the underlying principle. But the group or the session recognizes that in certain circumstances, consent may not be practical or impossible to be obtained, especially in relations to big data analytic as well as IoT initiative. So we recognize, or the group or the session recognizes, that there are problems in trying to get consent in certain circumstances. And we have two speakers for that session, Professor Hong and Ms. Naoko. And they enlightened us about the law in Japan and China. And these both countries basically provide exemption for the consent requirement in specific circumstances like big data and IoT. And we agree to some extent that there is a need for an option to this consent issue. Unfortunately, I have to be honest, we don't have the answer. I mean, what are the options to this notice and consent requirement? We try to explore the concept of transparency and whether or not technology can be used basically to replace this consent and notice issue. I'll stop there, and then I'll take up any questions. So.
Maybe, Jose, I might go to you and come to you later, but because I think that in your session, Latin America's way to deal with governance when consent is not effective is maybe best that you take the floor now after Professor Monier has said what he said. Go ahead.
Thank you, Jacob. And I think just to provide a little bit of context, we started our discussions by putting forward a recent document that has been a big important document in the Latin American community, which is the recently published standards, Ibero-American standards on data protection, which maybe for the first time recognize that consent is not the only mechanism available. Laws in Latin America have been heavily based on consent traditionally. Some countries more than others. Colombia's, for example, is an example where it's the only mechanism, and it's just exceptions to consent that are included. And the Ibero-American standards make a recognition of different bases for processing, and make a recognition of the principle of accountability as a way of providing better governance within companies. I think that there's a big recognition in the document of having effective measures and being able to demonstrate those measures to a regulator. Privacy impact assessments have been recognized in the document as well as a way of moving forward with good governance practices and actually understanding each time where those protections to the individual lie in. I would also say, unfortunately, I think you were very we were very optimistic that we were trying to come here and announce a solution. we're not going to announce a solution, but there were certain interesting things that arose. First was the discussion of going back to human dignity as the essential of data protection laws and regulations around the world. Sometimes consent has become the easy way out. It's easy for regulators, it's easy for companies, and it's very hard on the data subject. It's very, it just doesn't work. There was a talk of bringing education back to the table as a mean of better allowing the data subject to have better control of his information, providing more education. But of course, we know that's we just recently talked about it. It's not a perfect solution, but it's something that needs to be addressed. We had conversations around bringing together lawyers, bringing together technicians, bringing together tech people to find ways to provide more transparency, to provide more choice, real choice to individuals. So I think we didn't get to concrete solutions, but there was a highlighted effort on that paper on what it means, what it's going to mean for the discussion in Latin America going forward.
Well, thank you so much. That accountability, governance, privacy impact assessment, not getting away too far from consent is sort of outcome until now. But you have been talking about accountability in your side session. Go ahead.
This is on. So the topic I was given with the panel of really wonderful experts, a diversity of experts, was what about a world that is a post-consent world? Well, the problem I have is that I really don't believe in that. I don't think there will ever be a post-consent world. For example, human subject research, I really don't want to think of a time when we will not consent to, for example, DNA collection and other types of sensitive collections. So with that as a framework and an understanding that I don't think that there is such a thing as a completely post-consent world, we tried to find gradations of what might be possible in areas where there's quote-unquote big data or other situations where consent may not be possible. So we began with the idea of do no harm. So how does a do no harm principle work out when you are not gathering consent? How do you implement it practically? So there were various examples from the panel, and there was a focus on GDPR as a way of implementing a do no harm principle and a fairly robust implementation of a do no harm principle. There was another approach which was very interesting, and actually this came up a couple of times in the panel, which was using ethical guidelines from other industries that are dealing with highly sensitive information, such as, for example, medical research or pharmaceutical research, et cetera. And I thought that was an interesting theme that came through, where people who are being forced to implement this on the ground are looking for ethical guidance and very practical ways of implementing this. The next question we asked was a question that's come up in this conference several times, which is, what do you do with so-called pseudonymized, aggregate, or de-identified data? I don't like using the word anonymous data. I don't think that exists anymore. So I'll stick with de-identified and pseudonymized. There was a proposal in the EPIC's public voice side session from the Commissioner, the DPA of New Zealand, that perhaps we should not be re-identifying data without some real significant protections. I really agree with this, and the panel experts were quite interesting on this point. They all had a variety and actually a wealth of discussion and ideas about how to use de-identification, robust de-identification, as a very good potential tool. And I don't mean just a little bit. I mean truly, so you cannot re-identify. So I thought that was very interesting. And then one of the other questions we focused on is, how on earth do you weigh between societal benefit of collecting the data without consent and the risk to the individual? And the fairly uniform response came that you've got to have regulation in place. Without that, you're really sunk. You've got to have a cultural context in place that will support an ethical decision-making process. And on the ground level, at the implementation level, you need to have a cultural context within your own business or situations that supports decision-making that will provide adequate and actually robust checks and balances, which brings us to a risk assessment. There's really going to have to be, in those situations, a culture where risk assessment is indicated for all manner of things. It's not just a data breach risk, it's also a risk to the dignity and autonomy of the individual. So these were some of the themes that came out.
And finally, Malavika, and then I'll hand over to Malcolm to get the discussion going. Malavika.
Thank you, Jakob. When we met this morning to just over breakfast to discuss the structure of our sessions, I was very happy that I had the panel where we discussed the bridging project, because in a lot of the world we see such a fetishization around the idea of consent in pretty bland and meaningless ways. But as I was thinking about it later, I would prefer a world where we fetishize consent than where we fetishize data. So, it's still a step forward, and I think that's sort of, the point of view with which I went into our session. We had two speakers. We had one, Christina Irian, actually presenting the work from the Privacy Bridges Project, which is this wonderful report that I'm holding, and they have copies of it, but you can look at it online. It's a roadmap to enhancing user control via privacy dashboards. And so a lot of our discussion focused on the idea of a dashboard as one way of implementing consent, but one that basically upends the usual system where all of the control is in the hands of the companies and the platforms and the providers, but where you're actually giving agency to the end user, or the term that William Heath didn't like, the data subject, that mythical term. So we started off talking about how in this space there's a lot of what people classify as resignation, apathy, fatigue, when they're constantly asked to consent to various things. But equally, we were saying that isn't a sign that people don't care about privacy. It's also a sign that you need to make them more usable, you need to give people more autonomy and control, but you need to be sure that you're not mistaking something that's actually people feeling helplessness in the face of insanely complicated privacy policies and settings. It's not a sign that people don't care. It's more that they feel helpless in the face of this kind of assault. So we talked about dashboards as one simple way that you could actually work around this. And I think some of the central principles was ease, because at the end of the day, if people don't find it useful and easy to use, if it's going to reduce the user experience, people simply aren't going to use it. We talked about scalability, and I think that's still a challenge in this space. And we talked about respect. I think that's something that keeps coming through in this report, that it's about respect for user preferences. And it's really about user centricity at the end of the day, putting the user back at the center of the picture. And we then moved on to talking about YOTI, which is a platform for identity management and verification, which was one example. And I thought that was really useful, because often we're in this sort of echo chamber of people who work with law and policy but don't actually know how to code or actually create products and services that real users need to use and actually make money off of it. So it was a really good dialogue between someone who's actually implemented a project that actually tries to implement a lot of the principles within this report. And so Robin Toombs shared some of those lessons and about the architecture. And I think what came out very clearly in this panel was the idea that privacy dashboards are a really interesting way forward, because they do allow you a lot of room to play with the idea of privacy by design and by default. So the way in which you architect platforms and the way you make design choices is really instrumental in how people can then navigate preferences and actually exercise autonomy. And we went around the room and asked for other examples, other than dashboards, of ways that notice and consent could be improved on. And the idea of, whether people are just fatigued. And some of the examples that came up were on ad blockers, saying, you know, it's sort of this meta conversation around ad blockers, because, you know, it's an arms race, and every time you block something, there's something that blocks you blocking the ad blocker. And how the fact that that arms race even exists is a sign that people do care, and that when users actually exert choice in this space, companies do respond. And that was a very positive move. We also talked about a challenge from, and I think this is coming back to Marty's slide, which William referenced, the idea of how notice and consent makes sense where you have a one-on-one relationship between the data controller and the user, but where it's data that's derived or inferred from other sources, and you don't actually have a direct relationship to even go and secure consent, it sort of makes the idea of consent moot. So we talked about ways that could be addressed, and Marcelo Thompson at HKU talked about the specific challenges under the Hong Kong law and ordinance around how that's treated. And I think essentially we talked about how you need to look at this in an intersectional way, and you need to actually think of it in a socio-technical, you know, in a systemic way, and not look at it in silos. And because these are standalone pillars that don't scale. And we said, of course, the idea of having one dashboard that could manage all of your privacy preferences for every single app that you use is unrealistic, but maybe you could have a few. And we thought that it is still low-hanging fruit, and you still need to optimize the design to work around this. But essentially, I think it boils down to the question of trust. And by actually changing the relationship and saying the focus is on the end user, and it's more about vendor relationship management, to use sort of Doc Searle's terminology, you are actually shifting the focus, and it's not about what platforms are asking you to do, but what about users actually want. So I think it was a very empowering session for that reason.
Thank you. What I'm going to do is briefly sum up in 3 segments what I think we've learnt, and then we're going to see if there are people from the floor who would like to add their remarks as we try and make this as interactive an afternoon as we can. The start point really is that the time anybody has available to read notices or give consent is frankly a scarce resource. It's like chunks of gold sitting in your pocket. You've only got a small amount of it, and you have to spend it wisely. And that's not the way the world is working. It's scarce to be used in the right circumstance. We're wasting that at the moment. If we think about how we address using that scarce resource appropriately, I think the discussion breaks into about 3 segments. One of them is, can people be encouraged or helped to make better decisions? And that might either be wiser decisions, fully informed, or simply fully informed stupid decisions, but they're actually separate categories, those two. So education is that in that arena. The dashboards concept is talked about by the Privacy Bridges Project and so forth. They're all in that arena. How much of the problems or challenges that a company faces can be dealt with through de-identified information is another underexplored area that I think could be pushed further. As some people have pointed out in the GDPR and many other privacy laws around the world, notice and consent is only one of a number of options in the law. How about further exploring what's really possible in the other options? So those are about making sure we use the scarce resource well. If we then move on to another arena, it's how can the regulators, the data protection authorities, provide some facilitation to improve the world around us. And one of the concepts that was brought forward was the design jam, the ability for companies to sit down on a no prejudice basis with the regulators and think out loud with the regulators, or go beyond that to the sandbox concept and even be allowed to, with small communities or finite time or some other constraint, experiment with real people on what really works. The suggestion is that perhaps the regulators could engage more in the world of creativity in solving some of these problems. I think there's another one that was not explored today, but is a genuine issue for the DPAs to consider if they ever get given enough resources to do their jobs properly, which is to actually run a few court cases. If some of the consents that are given are as unfair and as unbalanced as we heard from William Heath, then surely a data protection regulator or a consumer protection regulator could consider taking some of these circumstances to court and seeing where they go, and see if in fact the courts can discover through tough enforcement that in fact some of these contracts are inappropriate, and that provides some guidance back in. We also heard, by the way, that the GDPR is likely to give us extreme transparency and extreme versions of affirmative consent, and that alone will bring things to a grinding halt for some of the allegedly more inappropriate reuses of people's personal information. It'll be interesting to see how that goes. One of the other ones that I think I've heard from some of the people who are running community-based companies or not-for-profit companies is that, again, is there a leg up or some facilitation that the regulators can give to the companies or organisations that are looking to stand in the shoes of the individual rather than to stand in the shoes of the profit-making entity? There is, beyond that, I think, a couple of things that have been brought out but only lightly. One of them is it's already happening in the health arena and has already been happening in the health arena for a long time, is that it is actually legal to use people's personal information for research purposes under very controlled circumstances, at least in Australia and certainly some other parts of the world, where so long as a review board or a health research ethics committee has overseen the process, considers that the research value significantly outweighs any privacy risks, and that the whole thing is properly governed, then in fact use of people's personal information without their knowledge or consent is in limited circumstances appropriate. Can those concepts be expanded out to other parts of the world than simply health research? In other words, are proper standards and rules set? Are appropriate governance processes in place? Are there appropriate authentication processes in place? And processes always for managing failure when it goes wrong, when somebody is insulted or the wrong information gets out. Because we must remember these are risk management processes. Mistakes will be made, mistakes already are made, they always have been. And the last one that hasn't been brought out, but I think is more future-oriented again, is who is going to develop the automaton that it can actually make decisions for me in my interests better than me without me knowing, but at least I'll be happy afterwards. That's definitely in Jakob's futures camp, and Jakob doesn't like the future. He likes the present and tomorrow, but not the long future. But I think we should also be thinking about the long future. If AI is going to be used to make so many decisions about us in this world, then how can we actually use AI in the interests of the individual rather than interests of other parties in our society? Hopefully we've been sufficiently provocative in everything that we have said that at least one person in the audience wants to stand up and provide a firm rebuttal or put forward another idea. And I do see a gentleman who's frequently in that position about to give us an offering. We're going to hear from Marc Rotenberg first of all, I think.
Thank you, Malcolm, and thank you, panel. If you were not sufficiently provocative, I hope that I am. I'd like to begin by suggesting that notice and consent as a concept is almost directly opposed to the principles of data protection. Data protection, of course, is based on the view that there are ongoing obligations associated with the collection and use of personal data, irrespective of any notice that might occur. And this is all the more critical in a world of big data where so much information about individuals flows to organizations without their awareness or without their participation. But more precisely, the problem with notice and consent is that it operates as what us lawyers call a waiver or disclaimer. It is the moment at which individuals give up their rights, because what they're consenting to is a whole series of vague and ambiguous uses of their personal data, which also, by the way, oftentimes change. So we have the notice and consent at the front end, which could be a privacy policy or privacy preference. It is subsequently changed, always to the detriment of the individual who has provided the consent in the first instance. It's frankly a waste of time. I'm disappointed to hear talk of dashboards nowadays. It was more than 15 years ago that we understood the difficulties with such proposals as the Platform for Privacy Preferences, which was seen as a way to extract personal data from individuals through dashboard-like techniques. But to make the argument from an economic perspective and not so much from a consumer protection perspective, I would recommend the work in the field of the behavioral economists. There's a very good reason today why consumers don't set privacy settings, don't read privacy policies, don't exercise their notice and consent options. They know it's not effective. And in the absence of their choice, what they are revealing is a lack of confidence in this particular technique for privacy protection. So my hope is that the outcome of this discussion will actually lead to recognition that when we talk about data protection, we're talking about ongoing obligations in the collection and use of data, irrespective of notice and choice mechanisms.
Can I ask you a follow-up question, Marc? So what is the solution? What's the proposition of what should be done?
Well, I would say implementation and enforcement of data protection obligations.
Serious question. I know you're going to probably jump on the stage at me, but does that mean all big data comes to a grinding halt regardless of how many babies' lives that it saves, or is there some other path that you have in mind?
Well, what I'm trying to explain is that, and I've written about this. I wrote about this, 20 years ago, and the point that I was making is that this is notice and choice. You see, is not actually in original privacy documents like the OECD guidelines. It was a construct that came about in response to a particular problem, which was the use of personal data for secondary purpose. And so the question is, if we're using your data for an unrelated purpose, do we have your affirmative agreement to do that? I've litigated dozens of these cases, and I'm fairly familiar with the law. But what I've seen over time as this has taken hold as a religion, we might say, a privacy religion, it's become the basis upon which users ultimately give up their privacy, because they invariably consent to things that do not provide protection and are not concrete terms and are not enforceable. And I think this is not a good road for the future of privacy. I hope that was sufficiently provocative.
Marc, would you give the microphone to Eduardo?
May I offer a solution? You asked for a solution. I fully agree with Marc, by the way. The solution, I'm going to make the suggestion based on what I know. I know European data protection law. The most advanced and sophisticated framework in Europe in relation to data protection is not yet fully applicable, but as probably every single person in the audience here knows, is coming in the form of the GDPR. The GDPR, from memory, has 3 articles out of 99, has 3 articles that refer to consent. 6, 7, and 9. The other 96 don't. My suggestion would be, let's focus on the other 96 articles. And there you have the solution of how to achieve data protection now and in the future.
Yeah, go ahead.
So thank you for your comments, and thank you, Marc. Obviously, one of the very challenging issues to deal with is that not every jurisdiction is going to have the GDPR. So in jurisdictions such as India, what on earth are people supposed to do when they do not have basic rights? And they have no data privacy protection, no even just standard processing protection. So while in Europe, the baseline regulation does provide protection and is wonderful because it does provide a very robust roadmap on how to protect rights that go along the terms that Marc was describing. In other jurisdictions, it doesn't leave them a good solution. I'm not saying that, some forms of consent are the only solution, but I am saying that there is a problem in this world of baseline regulation being strong enough and forceful enough to assure proper protections and processing and privacy. And I think that is something we can all work on, is to ensure that that exists.
Malavika, you wanted to go in?
I think one of the things we did raise in our session also was the idea that consent is a really ridiculous idea when you're dealing with people who can't make it in an informed, meaningful manner. So if you're dealing with a lot of Asia, where you're dealing with people who have issues of digital literacy, connectivity, where they're coming online for the very first time on a dumb phone or a smartphone, or they're doing it, in a walled garden in certain ways. They don't have access to the entire internet, and they don't have the literacy skills or the sophistication to navigate platforms. Expecting them to make informed and finely grained choices about how their privacy is to be managed is a huge ask. So we did sort of throw that out before we began, and while I'm not justifying dashboards at all, and it wasn't my paper, so I don't need to, you'll be happy to note that in the report they do talk about behavioral economists like Alessandro Acquisti's work. So I think that's interesting in the way that it talks about nudges. And the idea of privacy by default and design is also something we really discussed, because we said if you leave it to the end user to make choices, we know they either make crappy choices, they assess risk badly, they don't fully understand how their data is used. Even if you tell them, they will still make terrible choices in the moment. And it's sort of like all the problems with consent that Daniel Solov wrote about in The Consent Dilemma, when it's one-off, when it's upfront, when they don't have an option to delete, to revoke, all of those issues are still very much present. But I think to the extent that you are trying to say, bake it into the architecture, encode it by default into systems, and don't just leave it to end users, I think that's important, not just in poorer economies, but everywhere. Because if you look at all the debates around, privacy being a luxury, even in the West, stuff that Julie Angwin and others have talked about, I think it's a very real problem. So I think leaving it to the weakest person in the chain, which is the end user, to actually manage it, and you mentioned the cost of reading privacy policies and how long it takes, and Laurie Krainer's work around how many days it would take if we all read the terms, and let alone the emotional harm of actually reading some of that nonsense. That's a huge effective issue. But so I'm not saying dashboards are a solution, but I think the fact that we're even thinking along the lines of it being about users and not about companies and their profit motive is a good starting point. And there's lots of different ways to get there, whether it's dashboards or other solutions.
Thank you.
I just want to comment about the proposed solution to focus on the other 96 articles in the GDPR rather than the 3 articles. Yes, it's just 3 articles, but it provides the baseline, the underlying principle. And in fact, we like it or not, GDPR has basically enhances the requirement of consent. So, as compared to the directive, in certain circumstances, we can have implied consent. Now, under GDPR, it says explicit consent. So I'm not so sure whether the proposed solution is workable in that sense.
Marty. Short intervention?
It's short intervention, yes. The fact is that I agree wholeheartedly with Marc that data protection is about obligations, and the real commentary is about how organizations actually understand their obligations, how they're transparent about how they're going to exercise their obligations, what it means to be overseen for those obligations. And in so many ways, the future of data protection is about this recognition of obligations. Now, there is no single solution to every contextual question related to the appropriate use of information. There are absolutely times when individual consent is appropriate, but under Canadian law, and I spend a lot of time looking at Canadian law, consent is a door entry issue. The real issue in Canada is once you're in the door and have consent, how are you going to live up to the obligations that are based on accountability? So I think that there is a developing consensus about this concept of let's understand the obligations and how to manage those obligations. Thank you.
I think Marcelo Thompson, you want the floor? Raise your hand, then some, yeah.
I think the question of consent is also a question of agency, right? How to do away with consent without doing away with agency. And in a way, I think the proposal of the dashboards, though of course there are limitations with regard to what dashboards can accomplish, they provide a platform for certain reflexivity. Right? Because consent shouldn't be exercised only at the moment of the collection, but something that enables, it should be something that enables individuals to revisit those decisions at future moments as well. And if you remove the decision making from the individual towards the platform, you are doing away with the concept of agency. And we already have problems with that when we think of artificial intelligence and how artificial intelligence systems move us away from a conception of agency. Right? And so if we do away with the idea of consent, how can we do that, right? Without completely disempowering individuals to control the process. They will rely only on regulators. They will rely on the goodwill of corporations to make those decisions. Of course, those corporations will be bound by certain procedural mechanisms, but are they enough, right? So my question, my concern is, can we do away with consent without doing away with agency? And this is not a problem only of data protection, it's a problem also of contracts in general. So it's at the very foundation of law and how we understand law.
When I hear this part of the discussion, I'm reminded of the history of the motor car and the brakes in the motor car and the automated gear change. My very first motor car, the answer was four wheels, 4 cylinders, 4 drum brakes, and everything was utterly manual. So when I put my foot on the brake, that's exactly how much pressure was applied to the tyres to slow the car down. If I wanted to change the gear, I reached for the lever and changed it. Over time, all of that got automated. So I delegated to the motor car the decision as to when to change gears. Later on, I delegated to the motor car the decision as to how much it slowed the car down after I made a request to it to begin to think about doing that job. It then takes into account a series of other factors in the motor car as to whether or not it will slow the car down and at a certain speed, including is the car skidding, is the car tumbling over, are the wheels pointing in the same direction as the car's travel, and a series of other measures, and then the motor car decides how much pressure it will apply to the brakes. In a very short space of time, we're going to go to the driverless car, at least in some circumstances. So what we've watched is slowly, as we trust this vehicle, we've entrusted the vehicle with making more decisions on our behalf. But there are some decisions we still retain for ourselves, like, shall I get in the motor car and go somewhere, or shall I stay at home? And maybe the decision saying, let's follow this route instead of that route. But my point is, for most of the parts of our lives, we're asking entities, either animate or inanimate, to do things for us and do it in a circumstance that we trust. Can we bring some of that thinking to the management of personal information so that the scarce resource that we have, which is, as Marcelo has just said, the act of agency, which is a very finite human capability, is applied to the decisions that matter in the day and is not applied to the decisions that don't matter in the day, because other trust processes have led to appropriate decisions. Now, hopefully I've provoked Marc to get on his feet again, but if I haven't, I hope somebody else would like to.
Yep. There's one back there. Yeah, go ahead. Far away, so I can't see. Who is it? Get it. Yep.
Yeah. Just standing up. Hi, my name is Alex. I'm from Price International, a charity based in London. I had a comment and then a question. I was in a previous session on consent and choice, and a lot of the focus was on the burden, the imposition. This was on the billion-dollar industry that is the big data industry, and little focus on the harm, because I think we're talking about data subjects. We're talking about the impact of not getting consent from the start, but not necessarily as to what are the implications when consent is not sought. So that's something I wanted to just add to this around the harm and the implication. And my question was maybe for regulators, but mostly private companies as well. The question that we're discussing today has been going on for decades. And so I was just wondering if there are good practices, because I don't want to say best practices, because I don't think there are probably any, where respecting human rights and implementing data protection hasn't hindered innovation, hasn't hindered the digital economy, and can keep going. And to look at those good practices and see how they can be replicated. So that was more for the room, if anyone had anything to share on that.
So thank you. So our panel had the topic of what do you do when you are not going to collect consent. And that is why the very first question that I asked the panel is, how do you implement a do no harm principle? And the panelists discussed that from three completely different perspectives. I thought that what the Ireland DPA office had to say was very interesting, which was the GDPR has, in effect, operationalized a lot of the principles that you would find in do no harm. So there are articles which really discuss that and are quite specific to that. In other jurisdictions where there is not the GDPR, there are other considerations, such as ethical considerations and ethical frameworks that have been written in other industries that are very focused on do no harm. So those were some of the issues that we covered, but I'm going to leave it there. We're short on time.
Yes, go ahead.
Yes, and I also wanted to mention on that discussion and to Marc's point as well, and on shifting that burden and giving an additional role to the controllers who normally get the easy way out with mechanisms of consent. I think, and to add to the discussion of how to avoid harm and going into regulations, GDPR, Ibero-American standards who have considered it right now as to risk evaluations. I think there's also a big component which should be put into the equation, which is how do we assess benefits, and how do we assess benefits to individuals and those individual operations as a counterpoint to let's look at the risks, let's make the balancing tests, and let's look at the benefits for the individuals in each individual operation. And then we'll have a result in each project, processing activity by corporations, and can make an informed decision which is actually transparent to the individual. I think that's something that should be baked into the equation somehow.
Maravilla.
Yeah, one of the papers that I shared during our session was a paper that came out about a week ago by the National Bureau of Economic Research by Leslie Chow and Catherine Tucker, which actually debunks this idea that you can't actually provide accurate search results when you're looking for information unless you have so much data that personalization makes those results accurate and user-friendly. So they actually analyzed the impact of when they actually tweaked the ways in which they looked at results, and they found that when you actually change data retention requirements, when you reduced it to say 90 days, did that affect the quality of the search result? And they found that it actually didn't. It had very little impact on it. So I think we're beginning to see a move away from this idea that if you don't collect all the data that you possibly can, you're actually providing a poor service to the end user. I think that conversation is shifting in really interesting ways. So I think, and the other point that came out in our panel was when you've seen sort of the debacles around things like Equifax, you're slowly beginning to move away from this idea that data is the new gold, oil, currency, whatever you want to call it, and you're moving away to data as the big liability. It's toxic, it's an environmental hazard, it's pollution, it's kryptonite. So I think slowly people are beginning to realize that with great power comes great responsibility, to quote Spider-Man rather than any great data protection paper. But I think that's also a growing change in people's expectations around privacy as well. So I think those two trends are very encouraging.
I saw two more hands. Yes? Go ahead. And then Nico van Eyck, and just one after another so that we then can wrap up. Yeah, go ahead.
It's not 5 o'clock yet, so I don't feel bad holding cocktails. If you guys had a chance to go back in time to do things differently before the GDPR is even realized as an idea, much less in legislation, what would you do differently? Would you consider implementing a non-mandatory regime, much like the cybersecurity framework, since data protection was mentioned? Because that framework is non-mandatory, but the regulator, NIST, National Institute of Standards and Technology, actually works with industry and together collaborates with industry and puts out a series of guidelines that's constantly being modified. In fact, they had a meeting during the summertime to implement cybersecurity in a manner that's sensitive and flexible to changing scientific hacking technology and attack vectors. So in other words, it's adaptive and it's flexible. To what extent is the GDPR flexible and adaptive to hackers? Because they are constantly testing new attack vectors. Industry can't, because that assumes a strong and robust sandbox regime, which I don't know if we have one or not. So that's another question. Thank you very much.
Nico van Eyck, go ahead.
Yeah. Just a more or less short remark. I mean, several times there was reference to research. I'm an academic also, so let's do a little bit of a ratio pro domo. A lot of instruments might have not worked in the past because we just started stuff without really analyzing whether it was working. We get more and more evidence on what works or what doesn't work. What we don't have is a lot of, let's say, consent on whether that research is truly accepted, because every time we get new research that tries then to bring forward something differently. And I think it would be very nice if when we talk about dashboards and we in that context also explicitly mention that needs to be backed by empirical evidence, what works and what doesn't work, that we would find a little bit more agreement on when we cite all this research, that we discuss that research and understand whether or not it's research that we support or not. Because I see that also as a kind of issue where we can deliberately avoid discussion because although there is empirical evidence, we just don't recognize the empirical evidence as something that is valuable and could bring us forward. And either you use it as, oh no, it didn't work in the past and now we have new research and therefore it will maybe work in the future, or no, it didn't work in the past and it doesn't matter what kind of new research we get because it will, for all kind of other reasons, also not work. It would be very helpful if we had a little bit more level playing field on outcome of very relevant research, and that's only what I want to mention.
One more, and then we'll.
I'm going to try for a 10-second response to you. I think it is incredibly important that we put in place data governance systems that have robust feedback mechanisms so that what we are making decisions upon is evidence-based in regards to the actual risks that we are facing.
Okay, before Malcolm taking the floor, I just want to say that I was right. We didn't bring it all together, and that I was wrong that we would end at 5 o'clock because it's a couple of minutes later. But Malcolm is going to have a famous last word.
Going back to the gentleman who made the previous remark, if you think about it and you think about the motor car design process, stable law simply says the only kind of motor car that can be sold is a motor car that meets a standard, that there shall be a standards setting body and that there shall be a standards testing body. Parliament has never designed a motor car and hopefully Parliament never will. What we have in the case of data protection is Parliament's trying to write the standards. I suspect that what we need to do is to completely reconceive how the frameworks in which companies operate is reworked to a more flexible arrangement. And as you've described, there's a NIST process already out on the cyber side. There's the motor car design process. These models already exist, and we may need to think radically about how we do that for data in the future, but it fails Jacob's test, which is we can't do that tomorrow.
I think on that basis, I'm going to suggest that we wrap things up so that we don't fail our 5 o'clock deadline by too much. I want to thank our very hard-working moderators for having to, first of all, moderate a session and then report on their moderated sessions. I want to thank all of the agents provocateurs that we asked to be provocative during the breakout sessions. It's been hard work for a lot of people. I hope we've made you all think and to go home and continue the conversation. With that, I'm going to thank everybody and see you 100 floors up. Thank you.
Many thanks to our co-chairs and panelists, and that wraps up our session on notice of consent. But our day is not over yet. We will migrate our robust discussion to the Sky 100 reception at the ICC. There will be good food and plenty of performance-enhancing beverages. All members of the conference are invited, and may I remind you to please wear your conference badge, please. That's because we've taken over the entire venue there, and the badge is the identity, entry identification. We have arranged coach transport to bring you to the ICC. We will also bring you back here afterwards if you need it. Could we ask those of you who are joining the reception to meet back in this room at about 5:30 in the afternoon, shortly? If you prefer to get there yourself, of course, that would be fine too. See you shortly.